moved? Not moved. And Amendment 166 not moved. My Lords, that means that we come to the group of amendments beginning with Amendment 167. I'm after Clause 148, Amendment 167, Baroness Fox of Buckley.
So I rise to move Amendment 167 on resentencing those serving a sentence of imprisonment for public protection. I'd like to thank the noble Lords Moylan, Blunkett, Woodley and Earl Attlee, and I just say what a formidable cross-party, cross-house group of people that is. We've talked a lot about hopelessness, and I am aware that moving this amendment probably fits under that category, but I'm going to do it anyway. My Lords, along with other noble Lords, I want to warmly welcome the government's incremental reforms in relation to IPP sentences contained in the bill, this part of the bill. It's brilliant that they restore some sense of fairness for IPPs, especially on licence, by creating a realistic prospect that the sentence can be brought to a definite end in the foreseeable future. However, these moves will do little for the 1,227 people who we've discussed already tonight who have never been released, even though 98% of them have already served beyond their tariff, the majority of which were tariffs for less than 4 years. And yet 58% have been locked up for an additional 10 years on top of that original tariff. The proposed reforms also won't help the further 1,625 individuals in prison because they've been recalled, largely, as we've already discussed, due to minor licence breaches rather than because of committing further crimes. So that's nearly 3,000 people languishing in jail, effectively indefinitely, all due to this abolished and discredited sentence, and that I don't feel are helped enough by this bill. And this resentencing Amendment 167, which is based on the Justice Committee's recommendation, would resolve this iniquity, which is why it's backed by all serious commentators, professionals and campaigners on the issue. However, I do already know that the government planned to reject the proposal, and I was very disappointed saddened that the official opposition seemed to be backing the government on this as well when it was discussed in the other place. And I hope to persuade you all to move a little. I'll go through some of the arguments shortly, but firstly I want to acknowledge something important. The fact that this amendment is unlikely to succeed will be bitterly disappointing for people serving IPPs, their families and all those working so hard on their behalf. But inspired by them and their resilience, it's important that these issues continue to be aired, that we continue pressing. As Sir Bob Neill, who I think as chair of the Justice Committee can be described as something of a hero parliamentarian for tenaciously taking on this judicial aberration, as Bob Neill said, until we get resentencing in some form, there is unfinished business. But I'm also conscious that the noble Lord Bellamy gave a warning at second reading that, quote, the basic problem with the resentencing exercise is that you, people like me, are raising expectations that people will be released. Well, I don't want to falsely raise expectations, and I'm more than aware of that responsibility here tonight. Ringing in my ears, I have the words of Shirley de Bono from the IPP Committee in Action campaign. The last time that resentencing was rejected, she described the awful consequences of snatching away what she called the last chance, the last hope. And I'm more than conscious where this hopelessness can lead. And we've discussed the 86 people who serving IPPs have taken their own life while in prison, with the 9 self-inflicted deaths in 2023 alone, the highest number in a single year since the IPP was introduced. But also ringing in my ears are the words of the current Justice Secretary, Alex Chalk, remarks he made in 2017 about the toxic legacy of IPPs. And if I can quote him from then, society should not have a bleeding heart about its prisoners, but it shouldn't have blood on its hands either. And that blood on its hands cri de coeur is powerful. Indeed, it's daunting and humbling for all of us here today in terms of our responsibilities. But I also want to focus on Mr. Short's point that opposition to IPPs is not a bleeding heart approach. I think it's disingenuous to caricature this resentencing amendment, as some have done in other debates, as all for the sake of the prisoners, and that those of us who are putting it forward have a naive indifference to public safety. We should remember that we got into this mess precisely because imprisonment for public protection was originally sold to the public by New Labour under the banner of public safety. But actually, the public was sold a pop, and it failed abysmally. Of course the public want to be protected, and in the context of 2024, too many citizens feel the criminal justice system is not serving public safety well enough. For example, the public look on at early release schemes that seem to mean, for example, men who have physically and sexually abused women and children leaving prison potentially prematurely, in comparison, by the way, with IPP prisoners who are guilty of far less serious non-violent crimes who remain locked up. And then people, if you considered what the public are feeling at the moment about the crisis in policing, which means that various police forces are put into special measures, most recently Nottinghamshire for safeguarding concerns. Some victims' safety seems to get ignored. Look at those young women who suffered at the hands of the grooming gangs in the north of England while the police looked the other way. And then there's a general sense of insecurity as street crime is sidelined. Public disorder and intimidation on our streets seems to be given a free pass, or at least the police are confused. But rather than resolving those kind of thorny issues, instead we're told that it's these few thousand IPP prisoners who are a danger to the public, and it just feels like a distraction. In the other place, the Justice Secretary claimed, quote, "The fact remains that there are around 3,000 people in custody who the expert parole board has decided are dangerous." My reply, the fact remains that the criteria for labelling these specific prisoners as so dangerous they need to be held indefinitely is dodgy. Where is the evidence, for example, that IPPs are a distinct group of offenders more dangerous than, for example, others sentenced post the abolition of IPPs, who are subject to sentences with an eventual end date? And how can the facts justify the fact that an IPPer can be in the same prison, even share the same cell, as someone who has committed the very same crime, or worse, as on any objective measure of dangerousness? It's just based on an accident of timing, that is, that they were unlucky enough to be sentenced during the time when IPPs were applied. The reason they aren't released is not because of any crime they've committed, but due to what they might do in the future, based on speculation, not facts. Indeed, Alex Chalk talks of people who, quote, could go on to commit appalling crimes. Well, yes, they could, but that is purely hypothetical. So I have to ask, is this a new policy of preventative, pre-crime justice, locking people up in case something happens in the future? Because in the UK, we have a system of justice that every day lets all sorts of people leave prison, rightly, because they did the crime, but they've done their time. And of course, they may re-offend. They may create future victims. But unless we've decided to dispense with all sentences, just in case, as a civilised democratic society, we aim to manage that risk. Why are IPPs any different? Lord Bellamy has warned, again at second reading, that the people we are dealing with have been found not to be safe to be released, and calls them highly dangerous people. But how are these prisoners assessed as dangerous? It's certainly not based on their original crime, and it relies largely on two methods: the parole board's assessment and the fact that they've been recalled back into prison. On the parole boards, we've already heard about the especially stringent criteria demanded of prisoners, the onus on them to prove they're not a risk, and so on. And it's almost impossible, as the presumption is against parole. But most galling of the hoops that prisoners are asked to jump through to prove they're safe is attendance on designated courses, yet programmes are often postponed, cancelled, not available, in my experience. Meanwhile, a lack of transparent evaluation of these courses effectively means that we here, the Minister, let alone the parole boards, can't possibly guarantee these programmes are reliable evidence-based determination of dangerousness or otherwise. If, against all the odds, of course, the prisoners manage to get out over the hurdles, the fact that they're released on such ludicrously strict licence conditions mean they risk again being labelled as unsafe and again return to prison for infractions as petty as missed probation appointments that we've already heard about. But a startling 73% of recalls do not involve further proven offences, and they're often based on hearsay or accusations. Ishiba Salmon was released after spending 3 times his original 4-year tariff in jail. After 18 months, he was recalled, accused of GBH. But at Birmingham Crown Court, the prosecution offered no evidence and Ishiba was found not guilty. But it was too late because he was back inside. Surely this makes a mockery of exoneration by a court of law. The recall system for IPPs also makes a mockery of rehabilitation. Last week I met Ms Mandy Slade, the mother of David Parker, an IPP prisoner. He was recalled to prison with only 6 months left on his 10-year IPP licence. He's now currently held in HMP Bristol, not on a charge, just in custody on recall. For that nearly 10 years that he was released, David led a trouble-free life. He turned his life around. In fact, he owns a reefing business, he employed 3 people, a homeowner, financially supported his 3 children. Sadly, he and his partner had problems and his ex left the family home with the children, making allegations against him, having previously threatened to use the IPP to send him back to prison. The allegations were false, and we know that because the court heard David's case and all charges were dropped. But it's too late because IPP rules mean that 10 years of David's rehabilitation was all for nothing. He's back in prison, and now, under the way we're discussing it, because he's in prison, he's dubbed as dangerous. Such iniquities are now being tackled in terms of recall, as we've heard from the first group. But I raise it because when we're told that this resentencing amendment threatens to let out dangerous prisoners, a point reiterated by a range of people we've heard so far, Lord Ponsonby at the end of the first group and the Minister. That includes mislabelling David Parker and others like him. The Minister says the recall population is rising. Well, some of these should not be brought back to prison at all and are only there because of the specifics of IPP, this discredited sentence. David's mother, Mandy, who I met, suggested to me that her son could have been curfewed in the community or tagged in his own home. David's mum's common sense approach to managing risk is just the sort of spirit behind this resentencing amendment. It isn't extreme or unreasonable. Indeed, it's designed to provide such sensible solutions that should allay any fears that a resentencing exercise might be a chaotic mass release, as has been suggested in the past. There is plenty of oversight built in, and the amendment simply calls for a new sentence to be passed. But, and this is key, it doesn't require when or how it takes effect. This leaves room for an expert committee to examine and recommend any number of models that could minimise anticipated problems. For example, there could be a staggered resentencing exercise with a priority queue, beginning with those furthest over the tariff or who receive the shortest tariff. The new sentences could be issued on limited blocks of certain number per quarter to avoid mass release, and according to the Prison Reform Trust, 475 new sentences issued per quarter would address the entire imprisoned IPP cohort within 18 months. And when then it'd be done, we'd have finished. Alternately, the entire resentencing exercise could be completed within a stated period with a staggered system of release based on a priority queue, and where necessary, authorising referrals to mental health tribunals or reserving fresh judicial examination for any complex cases. You could even look at delaying the formal passing of a sentence for a fixed-term preparation period of maybe 6 months. And there's an element of this approach in the Noble Earl Ackley's interesting probing amendments to my amendment, suggesting a delay until the government is satisfied that the probation service has the capacity and resources to cope. I'm eager to see if this can assuage Labour's frontbench concern about a lack of infrastructure if resentencing is implemented immediately. If the opposition supported this, then I'd be happy to accept this as a step forward to getting resentencing on the statute books, even if there's a delay. Obviously, there's a worry that this might kick the decision into the long grass, but at this stage, I just want to emphasise that whether it's this government or a forthcoming Labour government, the issue of IPP prisoners needs to be fixed. It will be fixed. And this amendment gives a range of structured fixes because any of the models mentioned could be developed, adapted, and all with the help of an expert panel doing the necessary modelling and analysis to assess the cost-benefit analysis options. Regardless of the details, what's needed here is imagination, creativity, innovation, an approach that I've been delighted to see from this very government who embraced such a kind of sense of innovation in resolving the post office injustices, because it was an exceptional set of circumstances that the postmasters found themselves in. Well, the plight of IPP prisoners is also exceptional. After all, this Parliament abolished the sentence, deemed it no longer fit to remain on the statute books, and now, more than a decade later, these 3,000 prisoners are the last part of putting that wrong right. Finally, and I want to refer to the noble Lord Clark and the spat that he had with Lord Garnier earlier, or the discussion, I think it's important not to make assumptions about public opinion here, is my final point. When confronted with the facts, the British public are always repulsed by miscarriages of justice. They believe in fair play. Whenever I've got people to read the campaign group UNGRIP's important comprehensive archive of articles, or Faith Spear's criminal justice blog, or to listen to the brilliant podcast series Trapped, they are horrified. They are absolutely disgusted that this is the way people have been treated. And by the way, I include in that journalists too, and I even include in that Daily Mail journalists, because despite the way they're discussed here, as though they're a different breed, they are, after all, our fellow citizens. And we should be actually making sure that every member of the British public knows about this scandal, not keeping it in-house. Peter Stevanovich's video on the topic, which was mentioned by the noble Baroness Jones earlier in the first group, I think, has chalked up 14 million views in a matter of months. And the reaction is unanimously one of shock, outrage and disbelief. And as one respondent noted, let's not wait for an ITV drama to do the right thing. Hear, hear, I beg to move.
Amendment proposed after clause 48, insert the new clause as